There's nothing more exciting to me like that I get to work with Blake Lively and have her, all of her. I mean, that's what I want.
This newly leaked audio of Justin Baldoni's alleged apology to Blake Lively has ignited even more drama in the ongoing legal battle over It Ends With Us. The nearly 7-minute voice memo appears to reveal his regret over creative clashes, particularly around one scene, but what's the subtext? Is this a clue about alleged pressure he may have been feeling from Lively's powerful circle? And the release raises more questions. Was it leaked to help Baldoni's case, or does it reveal uncomfortable moments that could backfire? We're going to break it all down for you right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. A bombshell voice memo, seemingly from Justin Baldoni to Blake Lively, has just been leaked, adding even more fuel to their ongoing Hollywood legal drama. The nearly 7-minute recording, which was first released by Daily Mail, centers around an apology that Baldoni allegedly sent during the production of It Ends With Us. And in it, Baldoni, again the director and co-star of the film, addresses what appear to be creative clashes with Blake Lively over a pivotal scene. It's the iconic rooftop moment where their characters essentially meet for the first time or converse for the first time. This is an important moment in the film and also the book upon which the film is based. Now, according to Baldoni, this was just one disagreement that led to a full-blown feud. So I want to break down what apparently led up to this voice memo, and then we'll talk about it. So we're going back to April of 2023. During production, Lively reportedly asked Baldoni if she could rewrite this, again, iconic rooftop scene. And again, this film is based off of a novel of the same name. So this is a crucial moment for setting the film's tone. Now, Baldoni says he was hesitant for her to rewrite this because this was a very important scene, but he eventually gave in. And he says he gave in because he says he felt pressure from Lively's A-list husband, Ryan Reynolds, and another major celebrity, presumably Taylor Swift. So while Baldoni claims that both had praised Lively's edits, they spoke right in front of him, talked about how great her edits were, he was less enthusiastic, which he admits ultimately backfired on him. So now we got to talk about this leaked voice note. And first of all, we can't confirm who it was leaked by, but if it was leaked by Baldoni's camp, that fuels the narrative put forward by Blake Lively and Ryan Reynolds' side, that they say Baldoni's legal team is improperly litigating this case in the media, constantly talking about this case, releasing footage from the film, and now this. They actually have asked the court to step in, to stop, particularly Baldoni's attorney Brian Friedman, from doing this, from litigating this case in the public. If that's true, we don't know for sure. But after we listen to this, you gotta wonder, was it actually leaked by Baldoni's side? Would he want everyone to hear this? Does it really help his case? Because in this leaked voice note, apparently sent at 2 a.m, Baldoni addresses the tension surrounding the writing of this rooftop scene head on, offering what he seems to suggest is a heartfelt apology. Now, by the way, keep in mind something. 2 a.m. may sound like a strange time to leave a voice note, and arguably it might be, but it's our understanding this may have come 10 minutes or so after Lively had texted Baldoni about her concerns over his reaction to her rewrites of that scene. And we're going to get into what she wrote, but I want you to check this out.
I want to start with an apology. Man, reading the second part of your message, my heart sank, and I'm really sorry. I for sure fell short, and you worked really hard on that.
Hey everybody, this is another Law&Crime legal alert. So the Los Angeles wildfires are still making an impact, and it's estimated that the wildfires caused more than $250 billion worth in damage, and the loss of life truly immeasurable. There are reports that insurance companies canceled thousands of homeowners' fire policies in the months before the wildfire. Were those cancellations illegal? Will insurance companies be able to help people recover all that their families have lost? Well, I'll tell you what, Morgan & Morgan, America's largest injury law firm, they're here to help. They were there for the Northern California wildfires. They were there in Maui, and now they're here for you and the families affected by these horrific fires. So if you've lost loved ones, your home, business, property because of the Los Angeles wildfires, you can visit www.forthepeople.com/LCFire, and you may be entitled to significant compensation. Got to give you some context here. So Baldoni's apology centers on his initial hesitation to approve the changes that Lively had made to the rooftop scene, her rewrites. In his lawsuit, Baldoni claims that he felt compelled to follow Lively's script revisions after receiving praise from her powerful circle, Ryan Reynolds and Taylor Swift, who allegedly complimented Lively's work during a meeting at her Manhattan penthouse, that they were telling Baldoni how great this was. And text messages from the lawsuit reveal that Baldoni was telling Lively, quote, "Also was working on rooftop scene today. I really love what you did. It does help a lot. Makes it so much more fun and interesting. And I would have felt that way without Ryan and Taylor." So he arguably could be seen to be backtracking and saying, no, your revisions are great. He has come out and basically said, the only reason I said that is because I felt this pressure from A-listers like Ryan Reynolds and Taylor Swift. Now, in response, this is important, Lively reportedly texted him back, "I told them," again assuming this is Reynolds and Swift, "that you laughed a bunch and said it's probably a blend, but you appreciate my passion so much," which of course didn't feel great for me or them to have my passion praised instead of any specific contributions. So she was arguably insulted by his reaction to her rewrites, okay? But Baldoni, again, who now claims that he was under pressure, and whatever the case might be, we can all agree, Blake Lively sent that message to Justin Baldoni, and clearly she was not happy with what was going on. So he issues this apology through the voice memo. That's why he's saying, "I'm sorry, and I'm so sorry. Thank you for telling me how you feel." And Baldoni can be heard promising to make things right with Blake Lively, even admitting that he is a very flawed man.
I am far from perfect. I'm a very flawed man, as my wife will attest. And and I'm going to up. I'm going to say the wrong thing. I'm going to put my foot in my mouth. I'm going to piss you off, probably, but I will always apologize and find my way back to center.
Now, in Baldoni's lawsuit, and what appears to be part of Lively's response to Baldoni's apology, she seems to make a metaphorical comparison of herself to a Game of Thrones character and actually refers to Taylor Swift and Ryan Reynolds as dragons. That text reads, "If you ever get around to watching Game of Thrones, you'll appreciate that I, Khaleesi, and like her, I happen to have a few dragons. For better or worse, but usually for better, because my dragons also protect those I fight for. So really, we all benefit from those gorgeous monsters of mine. You will too, I can promise you." Now, the mention of Lively's dragon friends appears to be directly referenced in this voice note.
And damn right, you got great friends if that's how you felt and they knew that. And we should all have friends like that, aside from the fact that they're two of the most creative people on the planet. The three of you guys together is unbelievable. Talk about energy and just a force, all three of you. But I just wanted you to know that I didn't need that because it's really good and it's going to make the movie sing.
We've also discussed the alleged tension between these two during their on-set interactions, where Lively claims that she felt uncomfortable with what she described as intrusive behavior from Baldoni, while Baldoni insists their working relationship was positive, that he was genuinely excited about what they could build together. And this is reflected in the next part of this voice message, where he expresses excitement at spending more time with her.
I'm just excited to spend time with you. I'm excited to be in your sphere and your presence and for us to share creative juices together, although that sounds terrible.
Now, Baldoni also argued that in his lawsuit that because Lively allegedly felt comfortable enough to get vulnerable with him and converse casually, he felt he could reciprocate that energy. So listen to this next part from the voice memo.
You and I have been trying to build a relationship, which I think we've done successfully. I mean, here we are talking like this, me into my phone at 2 a.m, but largely via text and voice note. And that, I will be honest with you, that is not my biggest strength. I love being with people and being in somebody's space and being face to face. And I feel like that's where I excel. I'm just really looking forward to spending time together. And I think that's going to really go a long way for our chemistry, which I believe is there.
So Justin Baldoni's lawsuit suggests that he feared the potential difficulties or repercussions of what he could face if he didn't comply with Blake Lively's request, particularly when Lively allegedly texted him referencing, the influence of her husband Ryan Reynolds and Taylor Swift. The text reportedly reads, "They," again referencing Ryan Reynolds and Taylor Swift, "also know I'm not always good at making sure I'm seen and utilized for fear of threatening egos or fear of affecting the ease of the process. They don't give a blank about that. And because of that, everyone listens to them with immense respect and enthusiasm. So I guess I have to stop worrying about people liking me." Again, this seems to be what facilitated this voice memo. Now, Baldoni appears to apologize for any discomfort that Lively may have felt in the past, and ironically assures her that her experience on It Ends With Us will be very different, or at least that he hoped it would be.
I am so sorry you have been through what you've been through with these other filmmakers and producers or whoever the people were that you worked with. It just pissed me off. Those kids that, I'm just still kind of blown away that this is the industry that we're in and that you've experienced that as a woman. And I know I don't need to say it, but that's not at all going to be or will be. Hopefully it's not been the experience with me.
But as he expresses hope that her experience will be positive, he also goes on to say, in kind of an interesting way, that he's excited to work with her and, in his words, have all of her.
There's nothing more exciting to me like that I get to work with Blake Lively and have her, all of her. I mean, that's what I want.
Now, I'm not suggesting that's a sexual reference, but it is, that phrasing, an interesting way to express his enthusiasm about working with somebody, right? And Baldoni concludes the voice message by reaffirming his dedication to It Ends With Us, emphasizing his collaboration with a domestic violence organization to ensure the film resonates authentically, helps people heal. And that's important because apparently they had two different ways they marketed the film. He focused on the domestic violence aspect of the film, whereas Blake Lively was actually criticized for making it seem lighthearted and bring your florals and bring your friends. And I wonder if that's going to be an important point in that voice memo. But he ends, however, with something that is likely supposed to be a humorous reference to Lively's personal and family life. But take a listen.
I'm going to stop rambling because it's been 6 minutes and 30 seconds. So I'm sorry. You probably have kids all over you and a baby on your boob and you're listening to me ramble at 2 a.m. I hope you're feeling better, and give Ryan my love. Thank you for sending me that. It means the world to me that you trust me with your feelings and your thoughts like that. And I can't wait to spend more time with you. Okay, I'm done. Cutting myself off. Good night.
Okay, so from a legal point of view, it is hard to say who this voice note helps more, right? So on one hand, Baldoni could say, look, I was respectful of her. I acquiesced to her. If there were any issues that she felt, I was always receptive. I'm not the person that she has portrayed me to be. And by him apologizing, it's almost showing the power dynamic, right? That she had the power here. She had the control, not me. Would I really be in a position to create a hostile work environment and sexually harass someone as powerful as Blake Lively? That's an argument. On the other hand, the very fact that he left her a voice note at 2 a.m. and made arguably strange comments, wanting all of her, I'm just excited to spend time with you, even allegedly talked about her boob, that in and of itself could be argued by a well-seasoned lawyer to be a form of harassment. He was the director. Sure, Hollywood sets are different than offices, but workplace discrimination and harassment and hostile work environments, they all come into play. And even well-intentioned statements or actions could be illegal. And again, him acknowledging mistakes and issues that he may have caused or will cause, did he wrong her in some way? Again, I'm torn on who this voice note benefits and if it was actually released by Baldoni's side. And sure, we don't know for sure, but if it was this a good idea? Look, it seems the idea is reversing the public narrative in his favor, right? That would be the goal of putting all this out there in the public. This is the way to do it? So hopefully we'll get a little bit more clarity on that. But by the way, this is the second major piece of evidence to emerge since Baldoni filed his lawsuit against Blake Lively. So just last week, Brian Friedman, again Baldoni's attorney, released behind-the-scenes footage from a romantic montage on set, which he argues shows Lively wasn't uncomfortable around Baldoni. However, Lively's team claims the footage proves she was. In Lively's complaint, she alleges that Baldoni broke character during the scene, made an offhand comment like "it smells so good" when he was near her. Part of her lawsuit reads, Mr. Baldoni was caressing Miss Lively with his mouth in a way that had nothing to do with their roles. When Miss Lively later objected to this behavior, Mr. Baldoni's response was, I'm not even attracted to you. This is how that interaction played out on camera.
I'm not getting beard on you today.
I'm probably getting spray tan on you.
It smells good.
Well, it's not that. It's my body makeup.
That's part of the footage, by the way. And after it was dropped, Friedman announced plans to launch a website containing every text and email exchange between Baldoni and Lively to prove that he's not the guilty party. And in response, Lively's lawyers have filed a motion to try to stop Friedman from publicly disclosing case details. This reads in part, his conduct threatens to and will materially prejudice both the Lively case and the Wayfarer case by tainting the jury pool because his statements are deliberately aimed at undermining the character, credibility, reputation of numerous relevant parties, and likewise includes information the lawyer knows or reasonably should know is likely to be inadmissible as evidence at trial. So an initial pretrial conference is currently scheduled for next Monday to seemingly address this pretrial publicity and what was released. And we're going to expect to hear arguments regarding this on both sides, recap and setting the stage of where we are. Because now what we want to do is we have to talk about the latest filings in this case. And the first issue surrounds public statements and actions that have been taken since the start of this litigation. Now, before we go into Blake Lively and Ryan Reynolds' latest response, and we will go into that, we have to explain what we're talking about here. So on January 21st, 2025, the attorneys for Lively wrote a letter to the judge overseeing this case, the Honorable Louis J. Lyman from the Southern District of New York. This is a federal case. And by the way, this is not going to be Johnny Depp, Amber Heard again, because there are no cameras allowed in federal court. So we're not going to be able to see this. If it goes to a trial, we're not going to be able to see this play out in real time like we did last time with the other big high-profile case from a couple of years back. But going back to this letter. So this letter explained that when Lively had filed her complaint with the California Civil Rights Department, she provided a copy of that to the defendants, meaning defendants like Justin Baldoni, Wayfarer Studios, his production company, and so forth. But she also provided a cease and desist letter asking them to cease, quote, all unlawful conduct, namely what they alleged is the, quote, harassing and retaliatory media and online campaign against Miss Lively. But they say this hasn't stopped, that the defendant's attorney, Baldoni's attorney, Brian Friedman, this is who they're focusing on specifically, that they say almost every day he has done TV interviews, he's issued statements, he's appeared on podcasts, and that he even allegedly leaked information about the case, such as document preservation notices that were sent over. In other words, that he is improperly litigating this case in the media and the public and not the courtroom. So their argument is not only is this an example of further retaliation against Blake Lively for her stepping forward with her allegations, but they allege that Friedman is making false statements too. For example, to give you a sense of the statements that they have taken issue with respect to Brian Friedman, here is one of the statements that they cite in a separate exhibit. So this is a statement that was released to Deadline and other media outlets where Mr. Friedman reportedly stated, quote, I'm not going to speak to when or how many lawsuits we're filing, but when we file our first lawsuit, it is going to shock everyone who has been manipulated into believing a demonstrably false narrative. It will be supported by real evidence and tell the true story. In over 30 years of practicing, I have never seen this level of unethical behavior intentionally fueled through media manipulation. It reminds me of what NBC tried to do to Megyn Kelly and Gabrielle Union, and we all know how that ended up. Stand by. So Blake Lively, Ryan Reynolds, what they're saying is, look, we sent then a second cease and desist letter to Friedman directly. And they said that these allegedly defamatory, false, retaliatory statements, they are not protected by litigation privilege. What do I mean by that? That's basically the idea that litigants and their attorneys, they are protected from being sued for defamation in a lawsuit. And that makes sense, right? Because in every lawsuit, someone's going to be making claims that the other side will say is not true. You can't allow everyone to turn around and sue for defamation for that. We wouldn't really have lawsuits. It wouldn't work out that way. So here, while Friedman and Baldoni and the other defendants' lawyers could say, look, we're covered by litigation privilege, we're allowed to make these comments, Lively and Reynolds' lawyers are saying this is an exception. This crosses the line. The letter continues, since the Wayfarer parties and Mr. Friedman received the cease and desist letters, they have continued their harassing and retaliatory media campaign with almost daily media statements or other releases to the press. Earlier today, the Wayfarer parties leaked a video to the media that they have asserted is designed to refute the allegations. Now, that is the infamous video of Lively and Baldoni filming the montage scene on the set of It Ends With Us. It's them slow dancing. We've talked about this before. He alleges that this video is prime evidence that she was actually comfortable on set, that he wasn't doing anything creepy, that he wasn't harassing her, that she was the one who broke character, that she was the one who made inappropriate comments to him about his physical appearance. She had basically characterized this dance scene as him, improvising and, telling her she smells good and improvising how he was sniffing her and touching her and putting his lips near her. But again, he makes the allegation he was kind of the middleman between the intimacy coordinator and Blake Lively, and he was just kind of following through what the intimacy coordinator said. But moreover, he's saying, look, if you look at this scene that was captured on tape, you'll see there's nothing nefarious going on. She says this actually proves her point. There's an argument that she is hiding her discomfort with what he's saying and doing, and she's just trying to finish the scene like any kind of professional. Which way you take it, which way you perceive it, again, that'll be up to a jury or the fact finder. But the letter continues, alleging that Baldoni and the defendants and their counsel, they have indicated that they plan to create a website publishing all the text messages in this case. Again, they argue this is wrong. They say Friedman may even be violating the New York rules of professional conduct for lawyers by doing all this. Quote, his conduct threatens to and will materially prejudice both the Lively case and the Wayfarer case by tainting the jury pool because his statements are deliberately aimed at undermining the character, credibility, and reputation of numerous relevant parties, and likewise includes information the lawyer knows or reasonably should know is likely to be inadmissible as evidence at a trial, thereby creating a substantial risk of prejudice, not just for Miss Lively, but for numerous other parties in the matter. So they are asking the court to step in and say, hey, why didn't you ask the defendants if they actually plan to try this case in a courtroom or the court of public opinion? And Lively and Reynolds indicate they may seek a protective order to instruct the parties on what they can and cannot say here. And they are asking for an immediate hearing. So then we get a response from the defendants in this case. Baldoni, Wayfarer, Jamie Heath, Steve Sarowitz, Melissa Nathan, Jennifer Abel, these executives, PR representatives, crisis management experts. We get a response on January 23rd. And they argue that, quote, contrary to the inflammatory allegations in the Lively party's letter, they argue that Friedman and counsel didn't violate the rules of professional conduct. They write, quote, Rule 3.6a prohibits a lawyer who's participating in a civil matter from making extrajudicial statements, those are out-of-court statements, that will, quote, have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Putting aside that no such materially prejudicial statements have been made, Rule 3.6d creates an exception that allows the lawyer to make statements, quote, required to protect a client from the substantial prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. So the main argument from the defendants, Baldoni and his team, is, look, we're allowed to make these comments to the media and the public because it was Lively and her team who started this. They provided the New York Times with a copy of her civil rights complaint. They amplified this. They made it public, including the text messages and the emails that were then published in that bombshell New York Times report. The lawyers for Baldoni and his team write, the Times regurgitated Miss Lively's allegations along with an array of cherry-picked, altered, and misleadingly spliced communications. The results have been utterly calamitous for Mr. Baldoni and the other Wayfarer parties, who instantly became objects of public scorn and contempt. Already, the Wayfarer parties have been exiled from polite society and suffered damages totaling hundreds of millions of dollars due to Miss Lively's scorched earth media campaign. So they are saying this was coordinated, this was done to rehabilitate Lively's public image since she had faced so much bad press and online comments during the release of It Ends With Us. And Baldoni has been described now as an abuser. In other words, we have a right to respond. And that also, they say, includes us responding in the public to the montage dancing video that we put out. Why? Because, quote, the Lively party's counsel publicly described the contents of video footage relating to Miss Lively's allegations as damning. Their statement continued, any woman who's been inappropriately touched in the workplace will recognize Miss Lively's discomfort. In the context of a media feeding frenzy initiated by Miss Lively, counsel for the Wayfarer parties adamantly and good faith believe that a public response is required in order to avoid prejudice. The Lively parties desire to force the Wayfarer parties to defend themselves privately against allegations made publicly is not a proper basis for a gag order. Now, All of that in mind, now I can get into what was just filed. So we have this new filing from the attorneys for Blake Lively and Ryan Reynolds. So the defendants here say it's okay to do what they're doing because Lively provided a copy of her complaint to the New York Times and that she started this all first. They argue that is baseless and that is incorrect. But also, they write, it ignores that under well-established public policy and federal law, victims and survivors of sexual harassment and sexual assault have the freedom to report and publicly disclose their abuse. And they cite the Speak Out Act. So that is a federal law that was passed a few years back that, for one thing, invalidated agreements like NDAs that would have prevented somebody from speaking out about claims of sexual assault or harassment in the workplace. So Lively and Reynolds argue that, quote, the position that the New York Times reporting on the CRD complaint permanently justifies engaging in provocative and prejudicial publicity distorts applicable ethical rules beyond recognition. That Friedman has been focusing in his public statements on what they say is improperly assassinating Lively's character, that's wrong. They write, this public commentary, including that he will sue individuals into oblivion and will shock everyone who has been manipulated into believing a demonstrably false narrative, is nothing other than publicity purposely initiated by the lawyer or the lawyer's client to perpetuate a public narrative of Mr. Friedman's own creation. They say we haven't been doing this. They argue to the court that all of the statements that we have been making on behalf of our clients were on the up and up. They were purposely made in a, quote, responsive posture, and they were done in compliance with the rules of professional conduct. And they further argue that when Baldoni, Wayfair, and the other defendants claim that, quote, no materially prejudicial statement has been made, look at what Friedman has been saying. For example, Friedman told NBC News, I am more than willing to take every single text message that exists out there, lay them out, put them on a website for the world to see, have them see the truth and determine the truth for themselves. So Lively and Reynolds' lawyers write, quote, such repeated promises to take discoverable evidence and package it for publicity outside the judicial context will materially prejudice the truth-seeking function of this court. I mean, one of the big concerns, of course, is all of this going to prejudice a future jury? By the way, they also say, look, Blake Lively, Ryan Reynolds, despite the reporting out there, despite what the defense is saying, we aren't seeking a gag order in this case. This case is already public. What we're asking for is the lawyers to follow the ethical rules. And this is how the letter concludes from Lively and Reynolds' counsel. Quote, the Wayfair parties are attempting to draw a dangerous false equivalence that may have profound consequences, not just for this case, but for other women who are sexually harassed in the workplace, given the high profile of this matter. These actions arose from one of the most fundamentally protected activities under the law, speaking out against sexual harassment and retaliation in the workplace. Relentlessly publicly attacking a plaintiff in a sexual harassment and retaliation case in the media and on social media is not a protected activity. The Lively Reynolds parties have provided the court with the kind of language that the Wayfair parties' counsel has been using in the media on a regular basis, which is clearly designed to try to destroy Miss Lively's character and paint her as a controlling, demanding bully who brought this on herself. They also claim that with respect to the allegations that the defendants launched a social media campaign to manipulate the public against Lively, they argue this may still be happening. Quote, the Lively Reynolds parties are informed and believe that these efforts have continued unabated since the CRD complaint was filed and may have even been accelerated. The administration of justice in this case will be severely compromised if this behavior continues. Yeah, so quite the response, but that is not the end of the story. Why? Because right before we were about to record this episode, we just got an update about another filing from Lively and Reynolds' lawyers. I mean, just happened. Essentially, giving them more ammunition to their argument. Because in this new letter to the court, they write, quote, on Saturday, January 25th, 2025, in direct response to filings from the Lively Reynolds parties to this court regarding Mr. Friedman's recent prejudicial extrajudicial behavior, Mr. Friedman issued additional inflammatory content to tabloid media outlets that contains multiple false and defamatory statements and character attacks against Miss Lively. Those statements include, inter alia, that Miss Lively filed her California Civil Rights Department complaint with the sole intent to ruin the lives of innocent individuals and then went the extra mile to place blame on a fictitious smear campaign, and that Miss Lively's sexual harassment and retaliation complaint has devastated the entirety of the domestic violence community. Now, these statements apparently were reported by Page Six, but the lawyers go on to say, quote, Mr. Friedman also falsely asserted that the Lively Reynolds parties had raised concerns about his unethical and unprofessional behavior only because Miss Lively is fearful of the truth. That was apparently reported in a TMZ article. So they go on to say that what Friedman is doing is trying to influence the proceedings, taint a future jury pool, and they again say that this planned website to post selective communications and documents, what I mentioned before, it is going to be, quote, incomplete, biased, and prejudicial. And they say that Friedman's recent comments not only violate the ethics rules, which we talked about, but they say it also constitutes actionable defamation, meaning defamation they could sue for. And they end their letter by saying, quote, the endless stream of defamatory and extrajudicial media statements must end. It will not stop without this court's intervention. The Wayfarer defendants' efforts are being financed by a billionaire who has pledged to spend $100 million to ruin the lives of Miss Lively and her family. So that seems to be in reference to Steve Sarowitz. I mentioned him before. He's the apparent co-founder, co-chairman of Wayfarer. They write, quote, Mr. Friedman is using that money, his roster of current and former clients, and a blatant media and social media strategy to assassinate Miss Lively's character in advance of trial. Accordingly, the Lively Reynolds parties respectfully request a conference at the court's earliest convenience to address the concerns raised herein and in the Lively Reynolds parties' prior letters. Wow. All right. So you would think that's the end of the story. It is not, because I have one more thing I want to bring up. So the defendants, again, Wayfarer, Baldoni, Heath, Sarowitz, so forth, they have filed an official answer to Blake Lively's complaint. Now, to be clear, an answer doesn't get into the evidence and the defenses for each argument. Really, what it is going through, it goes through each line of the complaint, and they either admit it or they deny it or say they need more information. For example, at the very beginning it says, quote, answering the allegations in paragraph 1 of the complaint, defendant admits that a meeting was convened in New York on January 4th, 2024, prior to resuming filming of It Ends With Us. And as was laid out by Blake Lively, this was that all-hands meeting where she, Reynolds, Baldoni, different producers and executives, they attended to address certain issues before production resumed. But there are other things they admit too. For example, that they agreed to a list of demands from plaintiff. That's actually significant, by the way. So the defendant here doesn't admit that Baldoni engaged in sexual harassment or hostile work environment actions on the set, but they do admit that all the parties agreed to that 30-point list of demands from Blake Lively before production resumed, like no more showing nude photos or videos of women to Lively, or an intimacy coordinator must always be present. But remember what Baldoni's argument was. Baldoni's argument was, yeah, we agreed to all this. We didn't believe we did any of this, but, you know, as a way to move the production along, we said, okay, let's move forward. Now, I will say, it is also interesting that the defendants in this answer also admit that they sent text messages. I mean, when Lively produced copies of these text messages that she got through a subpoena, there's really nowhere else to go on that. You got to admit that you sent these, but it doesn't mean that Baldoni and the other defendants will agree to the context or the characterization that was laid out by Blake Lively. For instance, they write this, that the defendant admits the allegations that Mr. Baldoni sent communications containing the text set forth in the paragraph, and that was a text that he had sent Jennifer Abel, his PR representative, a screenshot with the message, this is what we need. So he admits that he sent the screenshot with the words, this is what we need. But the defendant, Justin Baldoni, also writes, quote, defendant denies all of the remaining allegations in the paragraph, meaning Lively's claim from her complaint that, quote, Mr. Baldoni set the narrative for the social media campaign, sending Miss Abel a screenshot of a thread on X that had accused another female celebrity of bullying women. So he's saying, basically, that's not why I sent the text. That's not what I meant by it. That's her characterization. We have a different characterization. But for pretty much everything else in this formal answer to Lively's complaint, it reads, answering the allegations in paragraph and whatever number it is, defendant denies such allegations, or defendant lacks knowledge or information sufficient to form a belief about the truth of such allegations, meaning it's too early in the case before discovery has even started to properly say whether or not something is true. This all started with when Blake Lively, the actress, first filed a civil rights complaint and then an official lawsuit against her co-star and the director of her movie It Ends With Us, accusing Justin Baldoni of sexual harassment, a hostile work environment on the set, and organizing a retaliatory PR campaign against her after she spoke about Baldoni's alleged misconduct. That's her main allegation. And she accused Baldoni of making inappropriate comments about her appearance, improvising intimate scenes on set, talking about pornography, coming into her trailer unannounced, including while she was breastfeeding. And she says, in terms of the retaliatory campaign that he allegedly spearheaded with a PR specialist and a crisis management expert, in her filing, she included screenshots of messages between the defendants that she obtained through a subpoena. Messages like, "I'm having reckless thoughts of wanting to plant pieces this week of how horrible Blake is to work with, just to get ahead of it." Or how about this, where Baldoni, quote, "wants to feel like she can be buried," with a response from the crisis manager, "You know we can bury anyone." Now, Baldoni not only countered this with a bombshell lawsuit of his own, but he basically accused Lively of deliberately misrepresenting situations and conversations to ruin his reputation, and also that she slowly took control over the film that he directed and produced. Because in his lawsuit, he included text conversations as well that he says refutes Lively's claims, such as a text where she allegedly invited him into her trailer while she was breastfeeding, or other conversations purportedly showing that she refused to meet with an intimacy coordinator and he had to be the middle person to work out the scenes with her. In other words, he tried to refute all of her allegations, and included in that is newly released footage from his lawyer, Brian Friedman, which is what we're going to get into. I should also tell you, by the way, that he sued the New York Times, too, for defamation, because they published a piece titled, "We Can Bury Anyone Inside a Hollywood Smear Machine," and this was published the day after Lively filed her complaint. And he said this was deliberate, that this had been worked out with Lively, and that the publication produced a misleading report on selective evidence, that it didn't publish the full context of what was happening. Now, we have dedicated, as I said, multiple sidebars to each lawsuit, including another one where a former publicist has sued Baldoni as well. And I encourage everybody who's interested in any of this, wants to do a deep dive on all of this, go check it out. All those episodes on Law&Crime's YouTube page. But right now, I want to focus on some major updates, including this newly released footage. But I'm not going to do it alone. I want to bring on friend of the show, fan favorite, Elizabeth Vulai, Law&Crime's general counsel, our attorney, who has been following the case so religiously. Elizabeth, good to see you. Thanks so much for coming on.
Thank you for having me on.
So as of right now, who do you think, whose story do you find more compelling? I mean, you've seen the different filings. Whose story is more compelling to you?
So initially when these claims first came out, when she came out with her complaint, I think a lot of people were shocked. They were thinking this really doesn't look so great for Justin Baldoni. But I have to say, in his complaint, at least based on the text messages and emails he provided in his complaint, he does show evidence of refuting a lot of the allegations, ones that you just mentioned, you know, where he produces text saying she invited him into her trailer to go over lines while she was breastfeeding, that she refused to meet with the intimacy coordinator. In her complaint, she said there wasn't even an intimacy coordinator. And then based on this newly released footage, I didn't really see evidence of harassment as much as just sort of an awkward interaction on camera.
In other words, would you say he's making some really good claims or defenses to the idea that he created a hostile work environment, that she maybe was taking control of the movie? What about, do you think he's done a thorough enough a job, an adequate job, a sufficient job of refuting the allegations that he and his team were behind the retaliatory campaign? Because she produced those text messages that when I covered it the first time, I said, these look really, really bad. It looks like it was a deliberate campaign to make her look bad in the press and try to cover up, you know, all of the allegations of fat shaming and all things like that. Do you think he's done a sufficient job of trying to refute that claim?
Yeah, I think there's two main threads that he's using, at least that I saw in his complaint and his defenses. So one is his attorney provided a lot of different examples of social media posts that Blake Lively herself posted during the promotion of the film. So one of their big defenses is they're saying she brought this negative backlash on herself. She chose to promote her alcohol line and her beauty or hair care line rather during a time when she's promoting a film about domestic violence, knowing the link that happens between alcohol and domestic violence. You know, there were a lot of social media posts in the complaint proving that. But then also I think you see an entirely other thread where he's saying, look, this isn't a smear campaign. This is just PR, right? You know, we know how PR works. PR professional's job is to be able to put out positive stories about their client and sometimes maybe plant negative stories about the opponent. So where do you draw the line between crisis PR, which he's saying he had to hire a crisis PR team because he's claiming he got backlash, versus a smear campaign?
How much of this is fighting in the court of public opinion versus actual going to trial? Why do I say that? Blake Lively chose to start this legal action. You could make the argument that she did it because she was getting a lot of negative press. You see on social media people going after her. It was her opportunity to reset the narrative and explain her side of the story. But if you take his allegations as true, why would you file a lawsuit knowing he's got these text messages and the footage that might refute your claims? Because his perspective could be, I don't want this going to trial. I'll put out everything right now for the public to see, make it look Blake Lively's allegations aren't true. I don't even care if this goes to trial. Maybe pressuring her to settle. Which do you see in the sense of how much are we talking about this actual, $250 million claim here, $400 million claim here, this is going to go to trial, versus we are fighting this out in the court of public opinion?
Yeah, I think that's a huge part of it. I heard someone on a different show say that there's two different trials, one in the legal courts, one in the court of public opinion. And one of the things that his attorney is claiming in his complaint was that Blake Lively and Ryan Reynolds had pressured Justin Baldoni and his team once the film was out and she was getting this negative backlash to put out a statement, basically, accounting, saying we behaved poorly on this set, there was misconduct, which they refused to do. And I think the thinking behind that might have been, hey, if they put out this statement taking some of the blame, the backlash against her on social media might start to lessen a little bit. They refused to do that, saying we did nothing wrong here. And then I think that's where a lot of the court of public opinion is coming out. And I also think, his complaint against her was 200 pages with tons of text messages, emails. That's fairly long. I haven't seen a federal complaint that long. So I think that's a big part of it.
I want to go to the footage now. This is what we really want to focus on, or one of the things we want to focus on, and then we'll get into the request for a gag order, which I think is really interesting. So I have to give you some context about this footage before I play it. So here is how Blake Lively explains this in her complaint. It reads, quote, on another occasion, Mr. Baldoni and Miss Lively were filming a slow dance scene for a montage in which no sound was recorded. By the way, their characters were, romantic interest in the movie. Mr. Baldoni chose to let the camera roll and have them perform the scene, but did not act in character as Ryle. Instead, he spoke to Miss Lively out of character as himself. At one point, he leaned forward and slowly dragged his lips from her ear and down her neck as he said, "It smells so good." None of this was remotely in character or based on any dialogue in the script, and nothing needed to be said because, again, there was no sound. Mr. Baldoni was caressing Miss Lively with his mouth in a way that had nothing to do with their roles. When Miss Lively later objected to this behavior, Mr. Baldoni's response was, "I'm not even attracted to you." But Baldoni has a different take on this, because in his complaint, it says, as they were acting in this montage scene, Lively continued to break character and speak as herself rather than as Lily, which was extremely confusing for Baldoni, who was trying to balance directing the scene within his artistic vision while also acting in character while filming and trying to get Lively to do the same. Lively apologized for the smell of her spray tan and body makeup. Baldoni responded, "It smells good," and continued acting, slow dancing as he believed his character would with his partner, which requires some amount of physical touching. Lively took them out of character again and began to joke about Baldoni's nose, which he laughed off and joked in turn, even as Lively joked that he should get plastic surgery. Lively incorrectly alleges that this scene was filmed without sound. Baldoni was wearing a microphone and the entire exchange is captured on camera. Any suggestion that this scene was filmed in any manner other than pure professionalism by Baldoni is unequivocally countered with actual evidence. Her allegation of sexual harassment is a documented and knowingly fabricated lie. Okay, so with that in mind, two different perspectives. I want you to watch for yourself, because Baldoni's attorney, Brian Friedman, released what appears to be the raw footage of this interaction. So first, this is about him allegedly dragging his lips against her and the smell comment.
Let's score another.
I'm getting beard on you today.
I'm probably getting spray tan on you.
It smells good.
Well, it's not bad. It's my body makeup.
And there's also this exchange about the nose.
It doesn't nosy.
I know.
And my noses.
And my nose is so big.
I was hoping that we could address this. It's not too late. Just gotta shut down. We gotta call an insurance month and just deal with that. And then
God.
just kidding.
No, it's true. That's why we hired Jenny Slate too. Our noses.
All right, so Elizabeth, after watching that, whose narrative does it support more, Blake Lively or Justin Baldoni?
Yeah, so I read both complaints, and when this footage came out, my initial thought was this really tends to prove what his version of events is in the complaint. So it's really clear when you watch the footage that they're acting out a scene, right? Because you hear him speaking to people in the background, people are saying action, he yells cut at the end. It's clear that they're filming a scene for the movie. It's supposed to be a montage scene, so there's no actual dialogue between their two characters, but their job is to portray these two characters who are in love and going through this sort of chaotic relationship as the movie progresses. So, one of the things that she's saying is, he leaned in too close to her, he caressed her, he said it smells so good. It paints sort of like a creepy, inappropriate picture. Yeah. But then in his version of events, he's saying, look, I'm trying to stay in character. This is a montage scene. We're trying to show these two characters who are attracted to each other. And when I watched the footage, it tended to veer more towards that description. And I think that footage he used to counter the harassment claims. And then also one of his claims where he's saying she's trying to hijack the movie, which goes into other claims in his complaint.
The counter argument is, look, she's a great actress. She might be hiding what she's feeling. She might be hiding because she wants to get this scene done. She's a professional. If she's really, not comfortable about what's going on, sure, she's Blake Lively. She could stop the production, tell them no, but she also has to get the job done. Could she be masking it? Could she be hiding what she's really feeling?
Yeah, there's a possibility. And actually, when this footage came out, her team came out and said, well, this footage just goes to prove what we've been alleging all along. You see that she's clearly uncomfortable. She's laughing. She's trying to say to Justin Baldoni, I think our characters should just talk and maybe not necessarily caress each other. So there is that possibility as well. And that's what her team is claiming.
By the way, I acted at one point in life. I don't encourage everybody to go check out my acting. It's nothing great. It's very awkward. I think that awkwardness also plays into this as well, right? I mean, particularly if you're a scene where there is no dialogue, right? There's not supposed to be. It's going to be covered over music. But in these scenes, sometimes actors joke about personal things just to heighten the mood, But I think that awkwardness is a factor to consider as well, right? I
think so. So when I watch the footage, I have to say props to actors because being in these kinds of scenes, it must be so uncomfortable when there's no dialogue to play off of, right? So I think that's one of the things that she's alleging is throughout her complaint is that she was made to feel uncomfortable. It was awkward for her. But, it also works both ways. He could use it to say, what he's saying in his complaint is I was trying to direct the scene. I was trying to stay in character. She kept breaking. This made it really difficult for me. So I think if you've got good lawyers on both sides, they can kind of spin it either way.
But the counter argument to that would be, okay, maybe she really was uncomfortable. She was trying to get through the scene. But she was the one who made a comment about his physical appearance, the nose comment. And, reverse it. You could have felt uncomfortable about that. And he, jokes around about his own nose. He said he has a big nose. And then he mentioned Jenny Slate, the actress in the movie. That nose comment, I think, is important, too.
It is. So I think that could be interpreted both ways. So when she makes a comment about his nose, he says in his complaint, well, I wasn't, because she's saying initially he made fun of her appearance, he fat shamed her. And then in his complaint, he's saying, actually, it was the other way around. She made a comment about my nose, implied I should get plastic surgery. But then at the very end, you hear him make a comment and saying, oh, yeah, my nose is big. That's why we hired Jenny Slate to be my sister, implying that he's saying Jenny Slate has a big nose. So it's, you could say she was sort of making fun of him and his appearance, but he also made a comment about one of the actresses.
But she was also saying get plastic surgery.
Yes.
But let me ask you about this. So his big allegation is, you say, Blake Lively, there was no intimacy coordinator. Well, I have messages that I was meeting with this intimacy coordinator. You didn't want to be a part of that. I have to now relay that choreographed situation with you on set. It's not entirely clear from this, but could it help explain why he's leaning in and caressing and going into her neck? I mean, What do you make of that from that footage? How much does that explain his narrative?
Yeah, it might be. So the role of an intimacy coordinator is fairly new in the industry. It really happened in the wake of the Me Too allegations back in 2017. So, I think the role of an intimacy coordinator obviously is to make sure that there is no awkward back and forth between the director and the actress. And obviously, director supposedly having more power than the actress. Here, since he's alleging that she didn't meet with the intimacy coordinator, that might be why he's trying to sort of freestyle it in the scene. I don't know from experience how much involvement intimacy coordinators have, if they work on mostly really intimate scenes or even just montages like this. But, his claim that she didn't meet with the intimacy coordinator might be why maybe they had to freestyle this.
Is it appropriate for them to be releasing this material into the public? Let me amplify that. The idea of releasing this video as opposed to at a court of law, releasing it for the public to see. And we also know that Brian Friedman, again, Baldoni's attorney, has announced that, and this is reported by outlets like Us Weekly, that they plan to launch a website containing all of the correspondence and videos in this case that they say is going to refute Lively's claims. I'm curious your thoughts on that, because then I will go into Blake Lively and Ryan Reynolds' response to that, where they believe that he's actually breaking professional rules and there should be a gag order. You think it's appropriate to do it like this, to release this information?
Yeah, I was a little surprised when they released this footage. So obviously one of their main goals is to sort of establish his defenses in the court of public opinion. That's clear. But, it's common for attorneys to go on talk shows like Brian Friedman has and talk freely about the case. But in terms of releasing evidence like this to the public before the trial goes underway, it is unusual. I haven't seen that happen that much. So I was a little bit surprised by that.
But it could be a way to pressure them to settle.
That was also one of my thoughts as well, is that people are saying, they're trying to clear his name. Yes, but it could also be a tactic from his attorney saying, hey, this is just the beginning of the material and evidence that we have. You might want to think about settling or withdrawing your claims.
The reason I ask you is because I want to now talk about if he's doing anything wrong, because Friedman is what he's doing has come into the attention, of course, of Blake Lively and Ryan Reynolds' lawyers over at Wilkie, Farr & Gallagher. If you don't know what this is, let me tell you, this is a very high-powered firm, okay? Very. And they wrote a letter to the district court judge who's overseeing this case, essentially requesting a gag order. I think that's a fair assertion, because they tell the judge, look, Lively filed her complaint with the California Civil Rights Department, and at the same time, a cease and desist letter was sent to Baldoni and the defendants, like Wayfair, his production company, demanding, quote, that they immediately cease and desist all unlawful conduct toward the Lively Reynolds parties and their affiliates, including their harassing and retaliatory media and online campaign against Miss Lively. And they attached a copy of that letter. And they also write, quote, immediately thereafter and virtually every day since, Mr. Friedman has given television interviews, appeared on podcasts, issued inflammatory written statements, and leaked information, including, remarkably, documents as banal as document preservation demands to third parties, to the Hollywood press and tabloid media. Those statements not only continue the campaign of retaliation that was the subject of Miss Lively's first cease and desist, but they contain numerous new false statements about Miss Lively and others. A list of public statements issued by Mr. Friedman, which is surely incomplete, is attached as Exhibit B, and it is attached there to the letter. And they argue that Mr. Friedman continued to make unprofessional and false statements. So Lively then sent a second cease and desist letter, sent it directly to Friedman, and they provided a copy of that letter too. And they write the second cease and desist letter directly addressed Mr. Friedman's ethical obligations, notified Mr. Friedman, as well as the managing partner of Mr. Friedman's law firm, that he had defamed and engaged in further unlawful retaliation against Miss Lively, and demanded that he immediately cease and desist from making further defamatory and retaliatory statements relating to Miss Lively. And they argue that none of this, what he's doing, is protected by the litigation privilege, which basically protects litigants from defamation claims. It makes sense, because in every lawsuit, someone's going to be making claims that the other side will say is not true. You can't allow everybody to just turn around and sue for defamation for that. But here, Lively and Reynolds say, or their lawyers say, there's an exception here. This is not allowed. So the letter continues, since the Wayfarer parties and Mr. Friedman received the cease and desist letters, they have continued their harassing and retaliatory media campaign with almost daily media statements or other releases to the press. Earlier today, the Wayfarer parties leaked a video to the media that they have asserted is designed to refute the allegations. They have further indicated that they intend to create a website to increase publicity around the exhibits filed. As counsel for Ms. Lively has made clear, these releases only reinforce the claims Ms. Lively advanced in her original complaint and continue to advance the campaign of retaliation alleged therein. But there is a more fundamental problem with Mr. Freeman's litigation via press statement strategy. As Ms. Lively's counsel have attempted repeatedly to caution Mr. Freeman, federal litigation must be conducted in court and according to the relevant rules of professional conduct. And this is where they say that he may have violated rules of professional conduct, like the rule against out-of-court statements that could likely substantially prejudice a trial or a jury. And then it goes on to say the Lively Reynolds parties intend to seek an appropriate protective order to govern further proceedings in this case. But given the imminent harm caused by Mr. Freeman's misleading and selective statements and leaks, we respectfully request that this court schedule a hearing as soon as possible to address the appropriate conduct of counsel moving forward in these two related matters. What exactly do you make of their argument? Are they asking for a gag order, and do you think they'll be successful? What do you make of what they're saying?
Yeah, so I definitely think they're asking for what's essentially a gag order. So the way that it works in the Southern District of New York is depending on which federal judge you have to make a request to the judge for a hearing. You can't just automatically file for a motion for a gag order for some judges. So I think that's what they're asking for here. I think the likelihood of it happening, it might be plausible, right? So generally federal judges are a little bit cautious with gag orders because it triggers, First Amendment, protection of free speech, protection of freedom of the press. But a lot of times in high profile cases like this, judges are more apt to grant them because I think their biggest worry is about tainting the jury pool, because no judge wants to be on a trial if this eventually gets to that point where they're trying to find, fair, impartial jurors, and it's taking weeks and weeks to do that because of what's played out in the media.
Yeah, it's an interesting response. And by the way, there's so much reporting on this. The Hollywood Reporter even reported that apparently Freeman had actually been in a legal action against Baldoni at one point, which raises potential conflict of interest situations, but maybe not. We'll talk about that on a different date. I will tell you, our research indicates that there is an initial conference set for this February 12th, 2025. So maybe we'll get more information then, maybe some information before. But Elizabeth Vulaj, thanks so much for coming on and breaking down the latest in this ongoing legal war that we're seeing play out.
Yeah, it's going to continue. Thank you for having me.
You got it. All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.